Hello, this is Scott Horton. I have just opened the webinar for attendees to enter, so we will get started in about 5 minutes after everyone has a chance to log in. If you're joining, hopefully you hear my voice and you can see the cover slide for our presentation, Preparing Employers for the New York HERO Act. I will keep chiming in the next couple of minutes occasionally, just so that people can test as they enter that they can hear me. But again, we will get started as scheduled in a few minutes. In the meantime, if you have access to the slide on your screen, the chat window, and you can hear my voice, then you are in good shape. It looks like people aren't having any trouble logging in for the most part, so hopefully that applies to you. Again, if you've just entered, we will get started in a couple of minutes as scheduled. Just give everyone a chance to get logged in. So I just typed into chat to welcome everyone. That is where you'll be able to enter questions that I will answer during the presentation or primarily at the end in the Q&A section of the presentation. But I do encourage anyone to type in questions as they have them. For this presentation, I'm not on screen, so as long as you can see the presentation slide, Preparing Employers for the New York HERO Act, and you can hear me, then you have what you need. Hopefully you can also access the chat so that you can type in questions if you have them. There's a question which I'll answer again as we get going and later on, but yes, the presentation slides will be made available at the end of the presentation. So you don't need to feel like you have to take down everything word for word. Sometimes what's most important is to make sure you take down the things that are not on the screen in front of you, because it's not just a transcript, and I will be adding some color commentary, if you will, as we go. So in about another minute or so, I will get started. It looks like a good number of people have been able to log in, so I'm hoping that there are not any technical problems. If you have any trouble, it most likely has to do with your system or internet connection or something like that. You can log out and try to re-enter the room, and often that fixes problems. If it doesn't, then you may also want to try closing any other applications on your computer or device, because sometimes those tie up resources that your computer otherwise could use to present the webinar. So it is 1 o'clock, which when we were scheduled to get started, and I will go ahead and do that. People who are still logging in won't miss much for the next moment or so. Anyway, just go over some of the preliminaries. Again, my name is Scott Horton with Horton Law PLLC in Orchard Park, New York, just outside of Buffalo. The presentation today will be a New York State specific topic, but it applies to any private employer meaning not governmental entity with at least one employee in New York State. That is to say, parts of the presentation encompass all employers. One part of the presentation, the second part, only applies to employers with 10 or more employees in New York State. So if that does not apply to you and you so choose, you could log out at that point in the presentation, which I will let you know again. But again, we will have general question and answers primarily at the end. Type in questions as you have them. And if I happen to see it at a point when I can work it into the presentation, I may do that. But again, I will stay on at the end of approximately 1 hour presentation to answer any questions that have been entered. And you can enter them at that point. I just don't want you to forget as we go along. Only keeping in mind that any questions you ask, I may read and answer here in an audience that includes some of my clients, many non-clients, and therefore is not a confidential communication with me, even if I do happen to be your lawyer. So if there's something confidential or sensitive that you don't want to ask here, you can certainly follow up offline with me separately. So today's topic specifically, I've entitled Preparing Employers for the New York HERO Act, first look at major workplace safety developments. So what we are talking about is a New York law that took effect earlier. Well, I shouldn't say took effect. It was signed by the governor earlier this month, and what that means for employers in the state of New York. The Health and Essential Rights Act, or HERO Act, was signed by Governor Cuomo about 2 weeks ago on May 5th. When the governor signed, he wrote in an approval memorandum that he was doing so subject to the legislature in Albany having agreed to make certain technical amendments. The way this works is that the law became law at the point in time that the governor signed it, but he had some objections, which he explained. With the agreement from legislative representatives that they would go back and make amendments to the law. However, the specific amendments to be made are not specified by the governor publicly anyway, and any amendments are still subject to being passed and approved by both houses of the New York legislature, and then once again being signed by the governor. So that adds a layer of complexity to this topic for now, but I will explain as we go that basically the amendments are now pending, so we can talk about what the amendments look like they will entail. However, again, they've not been finalized, so they could yet change. The HERO Act itself actually adds 2 new sections to the New York labor law, and the 2 sections are really entirely independent of each other. So from my perspective, having carefully studied the HERO Act, I think it's fair to say that the sort of public presentation of what this law is somewhat misleading. It is not a COVID-19 legislation. That is to say, it was clearly the result of the COVID-19 pandemic that this legislation was put forth and enacted as it was. But the full impact of the HERO Act has basically nothing to do with COVID-19, other than that being the impetus for getting it passed. As I mentioned before, everything in the HERO Act only applies to private businesses. However, that includes all for-profit and not-for-profit, non-governmental employers in New York. So if you have one employee and you're not the government, then you are subject to one of the 2 provisions of the New York labor law that the HERO Act created. You may be subject to the other if you have at least 10 employees in New York. So really, as I said, these are two different provisions of the New York labor law, and we're going to talk about them in turn. The first one is a set of requirements related to airborne infectious disease exposure prevention. Now, this is easily confused at this point with a COVID-19 specific piece of legislation. I think it's fair to say that under the law, COVID-19 would qualify as an airborne infectious disease, but the law doesn't say anything about COVID-19 or even coronavirus generally. It more broadly includes any possible airborne infectious diseases, which pretty much means any disease that has a significant potential impact on public health that can be transmitted through the air, as the name suggests. So every employer will need to adopt an airborne infectious disease exposure prevention plan. It's a real mouthful to do this, and there's not an obviously convenient abbreviation because of the way that the words are spelled out. And whether you want to call this an AIDS prevention plan is sort of questionable. Noting that HIV and AIDS itself would not be an airborne infectious disease, for example. But anyway, what is going to happen is the New York State Department of Labor must create industry-specific minimum standards and model plans. And based on the timing of the law itself and the anticipated amendments, it seems likely that the Department of Labor will have those standards and model plans out sometime this summer. But there is still some uncertainty, including the fact that the anticipated amendments to the law have not yet been enacted. Okay, so we've talked about this section of the labor law as covering private employers with at least one employee in New York State. Now we should think about the definition of employee, because it is very critical to note that for this new requirement of having these airborne infectious disease prevention plans, employee is defined more broadly than normal. It expressly includes independent contractors. It also includes individuals working for staffing agencies, contractors, subcontractors, and delivery personnel who are present on the employer's work site. So once you have a work site, as that's defined in the statute, then you may have employees who do not qualify as your employees for every position. So the amendments that I mentioned also have some wording that affects the definition of employee. So if that were to go in place, that would in some way clarify, in other ways expand this. Basically, the additional wording seems to specifically address the case of Uber and Lyft drivers, for example, because it says it includes people working for digital applications or platforms, and there's language specifically about vehicles. So it does, the work sites do include vehicles, but there is also a limitation on work site as any location where work is performed over which an employer has the ability to exercise control. That over which the employer has the ability to exercise control is not in the law as currently enacted, but is in the amendments that are expected to be enacted in some way, shape, or form. But again, we can't know yet for sure whether that language will survive the legislative process and ultimately be what affects the standards that go forward once the Department of Labor issues them. So for now, again, we just know that employees are much broader than just employee in the traditional sense of the term, which has already been interpreted fairly broadly, especially within New York. Once the law probably gets amended is when we expect the Department of Labor will start working on their minimum standards. The statute itself says that the minimum standards must include at least the following things. And I will let you know right now that you are now seeing the first of 3 slides listing required components of these standards as we work through it. And I won't read every word on these slides, but you will quickly start to recognize these components: employee health screenings, face coverings, PPE, protective clothing, respiratory devices, protective shields, barriers, and hygiene stations, regular cleaning and disinfecting of shared equipment, social distancing for employees, consumers, and customers, compliance, isolation, and quarantine orders, engineering controls, ventilation, designation of a supervisory employee to enforce compliance, the requirement that the employer comply with applicable laws or guidance on notification of potential exposure, verbal review of the infectious disease standard, employer policies and employee rights under the HERO Act with employees, and anti-retaliation protections. These are all things that must be in these new airborne disease exposure prevention plans. And if you've been involved in dealing with COVID compliance for your company in the past year or so, you will recognize that all of these things have been in the COVID-19 specific reopening guidance. So that clearly is where these components are coming from. So again, like I said, the law says nothing about coronavirus or COVID-19, but it clearly picks up on what the state did for COVID-19 and said, okay, these are all the things that we want you to have a preventative plan in place to protect against, or at least be prepared for, future airborne infectious disease outbreaks. It will be somewhat interesting to see what the state does on this, because I think the biggest vulnerability with the concept is that everything that came out from COVID-19, to the extent the science was available or became available, was based on COVID-19. That is not any sort of guarantee that all future airborne infectious diseases would have the same properties as COVID-19, such that is 6-foot distancing what's important for the next disease outbreak, or does it need to be more or less? Are the masks that we've been using for the last year or so just as effective against some future disease? Nobody knows at this point, probably. So I suspect what you will see are standards largely based on the COVID-19 experience, although directed at some generic concept of airborne infectious diseases, which will probably mean that no matter what plan you have in place, there's always going to be the potential heavy reliance on the compliance with applicable laws or guidance types of language, meaning that it's great that you have this plan in place, but if we actually get to another public health emergency involving an airborne infectious disease, you will probably have to change your plans, policies, and procedures based on whatever the government is telling us at that time is important for that specific disease. So, what are going to be your options for adopting this plan? Well, again, the state Department of Labor will have to come out with model plans with minimum standards. We'll talk about the timing of that in a minute. But once they do, your options as a private employer with at least one New York employee will be to either adopt the model plan that most closely matches your industry, So, just as with the reopening plan, there may be a plan for restaurants, there may be a plan for non food retail, there may be a plan for general office environment, there may be a school specific plan, there might be a manufacturing plan, what have you. With the COVID reopening plans, we saw dozens of these. There's no specific enumeration of how many there will be this time. There is in the proposed amendments a reference to a general plan that would apply if nothing else applies more specifically. But regardless, there will be some such plan that you will determine is the one of reference for your um, company. And then you can, apparently under the law, just adopt that plan and be all set on your compliance other than actually following the plan to the extent that it requires you to take some action on its terms. Your next possibility is to come up with an alternative plan. And if you choose to do that, the way the law is written, you must do one of two things. If you have a union that represents your employees, you must reach agreement with the union on an alternative plan. So, arguably, if you want to change one sentence in the model plan that applies to you based on your industry, then you can only do so with union consent. If you do not have a union, then the law still requires you to have meaningful participation of employees before you can implement an alternative plan. As you probably guessed, I have no idea what meaningful participation of employees is going to be interpreted to mean. It is not defined by the statute itself. It is quite likely that at some point in time, the Department of Labor will weigh in and tell us what it thinks meaningful participation of employees means, but their interpretation will probably just be that one interpretation. And it is possible that if they take too burdensome of a view, that some employers will decide that they think meaningful participation of employees means something different. It does seem clear that if there's no union, you don't have to get quote unquote employee agreement of an alternative plan. So presumably allowing them to somehow weigh in or provide comments may be sufficient. And then the company can adopt the plan however it likes. But again, if there's a union, they have to agree to the plan. And somebody asked the very good question that perhaps didn't occur to anyone in Albany. What happens if some employees are members of a union and other employees are not? Then I suppose you have different possibilities. You could agree to an alternative plan that only applies to the union employees, perhaps, and then come up with a non-union plan with meaningful participation of employees. You could possibly agree with the union on an alternative plan as long as your non-union employees participate. Or I suppose somebody could argue that as long as the employees through their union participated, then you've satisfied the meaningful participation of employees component, even if you don't have non-union employees involved in the process. Again, these are things that we might hope we get some further guidance from the Department of Labor to address. It is also worth noting, although I don't think it's a shocking concept, that any alternative plan must be tailored and specific to hazards in the specific industry and work sites of the employer. The only, I guess, real impact of that language seems to me that somebody could potentially argue down the road that something you put in your plan that varies from the model plan was not sufficiently tailored to specific hazards in your industry or your work sites, and that could create a dispute. But obviously, you shouldn't be having arbitrary and irrelevant components to your plan, and you probably wouldn't if you've reached agreement with the union or had meaningful participation of your employees. So here's the timing, and if somebody asked a question about this, there is no obligation to have this plan in place until the Department of Labor sets its minimum standards through the model plans. So yes, as of now, this component of the law takes effect on June 4th. However, I think it's highly unlikely that the Department of Labor is going to have these minimum standards and model plans out by June 4th. The pending amendment would change the effective date to basically July 4th, which I think is a Sunday, so may or may not roll to July 5th. But that is still somewhat irrelevant because again, Department of Labor have to have the standards out, and there's a pending amendment that would give employers 30 days to adopt their plan after the Department of Labor publishes the model standards. No matter what happens with the amendments, I think it's fair to assume that one way or the other between the Department of Labor and the legislature, they're going to try to give some plausibly reasonable amount of time for employers to comply. So I don't think anyone has to worry about having an airborne disease exposure prevention plan in place by June 4th. But you may need to as early as, say, early to mid-July. Once your plan is adopted under the amendments anyway, the employer has 30 days to provide the plan in writing to all existing employees. So it's not just going to be something that you create and hide. You'll have to post it as well, but you have to actually distribute it to all then existing employees. After that, whenever you hire new employees, it is something that you will have to give them at the time of hire. Again, some of this depends on the anticipated amendments, which may or may not actually get enacted before June 4th based on past experience. But regardless, until the Department of Labor puts standards out there, there's nothing that you have to do. One thing I didn't put in the slides is the Department of Labor is required to put these model plans out in both English and Spanish, and has the discretion to put it out in whatever additional language it feels are widely spoken in workplaces throughout New York State. Based on past experience, there's a dozen or so languages that the Department of Labor usually looks to for these purposes. But if there is a model plan in a particular language, then you must give your plan to employees for whom that is their primary language in that language. So if you have people that speak Spanish, you will have to give them and that's their primary language, you will have to give them your airborne disease exposure prevention plan in Spanish. And that applies even if you choose to prepare an alternative plan and not adopt the state model plan, which means you would then have to translate your plan into Spanish. I think it's fair to anticipate that in time, at least, the Department of Labor will also have this requirement for languages such as Russian, Mandarin, and various others that they use already for things like the wage notice requirements. Let me try to answer this question that just came up because it actually raises an interesting point. How long for plan implementation once it's adopted? There's not really a particular directive on that. It could be something the Department of Labor addresses depending on what these standards are. But it does raise sort of the open question of whether you have to do anything to implement the plan that you put in place. It's somewhat unclear whether by the time this takes effect, COVID-19 will still qualify as an airborne infectious disease, because the definition of that which I didn't put on here, does require that there be some form of public health concern ongoing. It means any infectious viral, bacterial, or fungal disease that is transmissible through the air in the form of aerosol particulates or particles or droplets and is designated a highly contagious communicable disease that presents a serious risk of harm to the public health. The reason I didn't put that in the slide is because that itself is subject to amendments. There are proposed amendments to that wording, but that's basically the gist of it one way or the other. So the Commissioner of Health has to designate whether there is an airborne infectious disease in place. So COVID could qualify at that point in time, in which case you would have to comply with whatever is in your plan, presumably effective immediately. But the overall gist of the way the law is written is more that when there is a future airborne infectious disease outbreak, you would then have to be following your plan, presumably effective immediately or as quickly as that outbreak gets designated. The standards also talk about this making distinctions in what's required, whether or not a state of emergency has been declared, as it was for COVID-19. So a lot of those types of questions are really going to depend on what the minimum standard set by the Department of Labor is, the timing of that, and what the status of COVID-19 or theoretically some different future disease is. There are some employee protections, of course, in this legislation. Employers may not take adverse action against employees for doing any of the following things: exercising their rights under Section 218B of the labor law, which is the new section that encompasses this airborne infectious disease prevention plan requirement, or exercising their rights under the applicable plan. So employees don't have that many express rights in the statute itself, but they might have rights or protections under the plan. So if they avail themselves of that and they are disciplined, then the employer is in violation of the law. They also have the right to report violations of the law or the plan. So that could be reporting that their employer hasn't put a plan in place or did so improperly, or the plan's non-compliant. Or again, once the plan's in place and applies to some situation, that the employee could claim that the company didn't do what they were supposed to do under the plan, then they cannot be disciplined for that report. More generally, reporting an airborne infectious disease exposure concern. Or the last one is refusing to work based on a good faith belief of an unreasonable risk of exposure to an airborne infectious disease due to the existence of working conditions that are inconsistent with laws or other government orders, despite notice to the employer of the inconsistent working conditions that the employer failed to address. It's actually a typo there, so where it says inconstant, that should have been inconsistent. But the whole idea here is if the employee believes that the company is unreasonably exposing them to airborne infectious disease transmission and they notify the employer of that belief, then they have the right to stop working and could not be disciplined for doing so. I would anticipate that component would be one that the Department of Labor will consider and hopefully issue further guidance to explain. But I also hope that most of you will not have a situation where it comes up that an employee believes that you're unreasonably exposing them to airborne infectious diseases. However, I've been doing this long enough to know that there will be some employees who do indeed raise such an issue. Finally, on this component of the HERO Act, the penalties are not friendly. there's a $50 per day fine for not having your plan in place, and then a fine of $1,000 to $10,000 for each violation of the plan. Again, we don't know exactly what these plans are going to look like yet, so it's hard to know what the violation could entail. But assuming it says while there's a pandemic going on, you have to provide masks to your employees. If you, for some reason, refuse to do that or refuse to allow them to wear masks that they're entitled to wear under the plan, then that might result in a fine by the Department of Labor. In the case of repeated fines, the fines can be higher. I believe the not having your plan in place jumps to $200 per day in that scenario. You would hope by the time you got penalized once for not having a plan in place, you would just put a plan in place, but the law does provide for higher penalties in that situation. The law also allows employees to sue for alleged violations of a plan that creates a substantial probability that death or serious physical harm could result. One of the amendments would clarify that that means that any individual employee can only sue based on the probability of death or serious physical harm resulting to them personally rather than to the public at large or to other employees. But that is in there. The amendments also propose, and this is something that was apparently suggested as a condition for the governor's approval, that employees have to first give 30 days notice to, I'm afraid it's another typo, to the employer to provide them an opportunity to correct the violation before they could then sue for a substantial probability that death or serious physical harm could result. There's also some proposed language with that amendment, though, that would say, something to the effect of if the employee reasonably believed based on past circumstances that the employer wasn't going to take any action, then they may not have to provide that 30-day notice with opportunity to cure. Finally, in cases of discrimination or retaliation against an employee for engaging in some protected activity under the law, so reporting a violation, for example, then there are compensatory and liquidated damages, among other relief, like lost wages and attorney's fees that you would see in other employment discrimination cases. So that is the first half of the New York HERO Act, and it's the one that perhaps most directly relates to COVID-19, although, again, as I said, it doesn't, in fact, limit itself to COVID-19 and is more written with an eye toward future airborne infectious disease outbreaks. The other more generally applicable aspect of the HERO Act is a new section of the labor law, Section 27D, that applies to a slightly smaller subset of private employers because you have to have at least 10 employees in New York. Probably most of you that are watching this webinar are with organizations that have at least 10 employees in New York. But if you don't and feel that you never will and aren't interested, you could stop watching the presentation now. Although, again, there are a number of questions that will be addressed yet in question and answer, so you may want to stick around for that, if nothing else. The covered employers, so 10 or more employees and not a governmental entity, must permit employees to establish and administer a joint labor management workplace safety committee. Now, this is publicly explained various ways, and I can only tell you with certainty what the statute itself says. But I think what this means by permit employees to establish is that if you have employees who want to form a workplace safety committee, then they will be able to form the workplace safety committee. I don't think it means you as an employer have an obligation to go out and tell employees that you want them to form this safety committee, or to go to your employees and say, we have to have a safety committee, so form one. But again, that is only my reading of it at this point. The Department of Labor, again, will be required to issue regulations, and I expect this is one of the numerous issues they will address in those regulations. When we will see those regulations, who knows? This component of the HERO Act is scheduled to take effect November 1st, 2021. So if employees come to you tomorrow and say they're ready to form their workplace safety committee, you're able to allow them to do that, but you do not have to allow them to do that until November 1st, 2021. And I think it would be prudent, if that were your situation, to tell those employees, yeah, we understand that you'd like to do that, and we know about the HERO Act, but it doesn't take effect until November 1st, 2021. And for now, we don't want to go down that road because we don't have all the guidance that we're anticipating from the Department of Labor yet to tell us how to set those up properly. And we don't want to, go through the trouble of having this all set up in a way that we will then have to redo in a few months once we have that guidance. So hopefully you can use that to put people on hold. If, however, you want to move forward, then we're going to talk about the main criteria and what we know based on the statutory language. There's no specific number of people who have to be on these workplace safety committees, but the law is clear that at least 2/3 of them must be non-supervisory employees. Now, here is one area where the legislature didn't really do anybody a favor by putting these two separate sections of the labor law in the same thing that they're calling the HERO Act, because while they did define non-supervisory employee for purposes of the airborne infectious disease provisions, that definition does not actually govern directly anyway the workplace safety committee section of the labor law. So I suspect they meant for the same definition to apply to both sections, but they should have been more careful, and perhaps will be by the time they amend the legislation, more careful to make their definitions cross over. But for now, employee itself is defined in the more traditional sense without the express inclusion of independent contractors, staffing employees, staffing company workers, and the so-called gig economy types of workers that arguably are not employees. So draw the line there, as well as the fact that non-supervisory employees has an undefined meaning for the Workplace Safety Committee statute. Although I suspect that if the legislature doesn't get around to it, then the Department of Labor will come in and use the definition from the other section to explain what they're going to interpret this to mean. Okay, beyond that, each committee must apparently be co-chaired by one representative, each of the employer and the non-supervisory employees. So that means every workplace safety committee will have two co-chairs, one of which has to be a non-supervisory employee. For sake of clarification, I'm assuming the other is a supervisory employee. The complication arises with the next component, where employers, at least based on the amendments, are not going to be required to recognize more than one workplace safety committee per work site. We had the question earlier, what happens if some of your employees are in a union and others are not? That creates the complication in how you're going to make up these workplace safety committees. You could have more than one, but you don't have to. So how is the non-supervisory employee representative going to get chosen as between the union group and the non-union group? We don't know at this point. I suppose it could be majority rules, and perhaps that's what the Department of Labor will tell us. But just to make everyone's life somewhat easier, hopefully they do address that in regulations before November 1st. The law says that no employer shall interfere with the selection of employees who shall serve on such committee or who serve as the workplace safety designee or with such employees' performance of the duties authorized under this section 27D of the labor law. There's a lot here. There's nothing in the amendment so far to suggest they're going to change this, but there's some problems with this statement. I think we get the general gist that the employer doesn't get to pick who the non-supervisory employees on the workplace safety committee are. Like I said, exactly how those people get selected is uncertain. When there is a union and perhaps they represent all non-supervisory employees, then I think it's clear the union is going to figure out how to select the people. But when there are any non-unionized employees, there's no established mechanism typically to determine how they're going to select among themselves, but the employer can't interfere with that process. I suspect interfere might ultimately be read to mean that you can tell your employees what the Department of Labor guidance or regulations suggests they do, for example. But again, that remains to be seen. This reference here that you can't interfere with who shall serve as the workplace safety designee is kind of confusing because there's no other reference in the law to the workplace safety designee. So it's not clear whether that's intended to mean the um, the co-chair and whether I mean, presumably it must not mean the employer's representative as the co-chair because it seems like the employer must have the right to determine who that is. Maybe that it means who is the non-supervisory employees co-chair. Maybe it just means the person that the committee designates for some other purposes under the law, but that's somewhat unclear. I mean, the easiest part of this to digest is probably the last part. So the employer can't interfere with the employee's performance of their duties under the law. And here are the duties that the statute gives them. They can raise health and safety concerns, hazards, complaints, and violations to which the employer must respond. So in the union context, we have grievances. So you might call this a health and safety grievance. It says that the employer must respond. So if there is no negotiated grievance procedure, there's no union, then it may be that just the employer has to respond and say, we don't agree that there's a health and safety concern. And that might be the end of it, other than the possibility of the employees going to the Department of Labor or a court and making some sort of complaint there. There's also the question of what's a health and safety concern. Does this encompass something like sick leave or other time off where someone says, if you don't give me a paid holiday, then I'll have to work and I'll be stressed out. So again, how broadly do you want to interpret these things? And will the Department of Labor tell us how broadly they think it should be interpreted? The next item on this list is one that really jumped out at me when I first read the statute. The strike through and underlining is from the proposed amendment legislation. But let me explain the distinction. So the original law, which is on the books now, says review any policy put in place in the workplace required by the New York labor law or the workers' compensation law and provide feedback to such policy in a manner consistent with any provision of law. So there are numerous requirements under the New York labor law. So it is possible you could read that to say anytime there's a workplace policy that relates to any provision of the New York labor law, say vacation or holiday pay issues, or your sexual harassment prevention policy is a requirement under the New York labor law, are these things that the Workplace Safety Committee has the right to provide feedback on. The proposed amendment takes out the workers' compensation law reference to change this to read any policy put in place in the workplace required by the New York labor law relating to occupational safety and health, and provide feedback to such policy in a manner consistent with any provision of law. Well, that presumably would now mean your airborne disease exposure prevention plan, which is another component of the New York labor law, as we just discussed. And there might be other existing components of the New York labor law that relate to occupational safety and health. But again, it begs the question of what's occupational safety and health. Is that different than a health and safety concern because it has the word occupation and it switches the order of safety and health? I mean, these are the types of arguments that lawyers at some point are going to get paid to make. But again, it would make everyone's lives easier, or at least hopefully somewhat easier, if the Department of Labor addresses these in regulations sooner rather than later and before November 1st. Other requirements, committee duties: review the adoption of any policy in the workplace in response to any health or safety law, ordinance, rule, regulation, executive order, or other related directive. One might wonder why you have the previous bullet if you also have that bullet limited to health or safety. So again, there's problems with the way this was written, but that generally doesn't stop the legislature anyway. They can participate in any site visit by any governmental entity responsible for enforcing safety and health standards. Easiest way to think of this is if OSHA, the Occupational Safety and Health Administration, comes in to investigate something on the work site, then the Workplace Safety Committee has a right to participate in that investigation. Does that mean the entire Workplace Safety Committee? Do they have to designate someone? Is it the co-chairs? There's no elaboration on that. They get to review any report filed by the employer related to the health and safety of the workplace. So not specifically aware of a example other than, I suppose, the OSHA reporting requirements that you have for how many accidents and injuries there have been in the workplace in a given period of time, or if there is, for example, a fatality in the workplace, that would be a reportable incident in most cases. I suppose they can review that report. There may be other things that would be encompassed in this language. And finally, in this enumerated list, the committee can regularly schedule a meeting during work hours at least once a quarter. The underlined bolded language here is again from the amendments, where they have added the restriction that they shall last no longer than 2 hours. Remember, this is during work hours. Is likely this means with pay, or almost certainly it means with pay. So I guess the lasting no longer than 2 hours was supposed to be some sort of check on this provision. But if that's the only change that gets made, you still have the problem that the committee can schedule a meeting at least once a quarter. And therefore, you could argue that they can have as many meetings as they want in any quarter, meaning anytime they want, as long as each meeting doesn't last longer than 2 hours. So theoretically they could meet for 2 hours every day of the week, as long as I guess they have something to talk about, or arguably has something to talk about. So there is still some problematic ambiguity there, even if that amendment goes through. Another pay obligation for the company is that employers shall permit safety committee designees to attend a training of no longer than 4 hours without suffering a loss of pay on the function of worker safety committees, rights established under this section, and an introduction to occupational safety and health. It is probably reasonable to guess that the Department of Labor at some point will be coming out with some form of such training, as they did with the sexual harassment prevention training a few years ago. But there again is the issue of this underlined bold language in the amendments, no longer than 4 hours. Does that mean each individual training session can be no longer than 4 hours, or does it mean that there's a one-time training of no longer than 4 hours? I actually do think there's a strong argument that this wording is limited to a single training of no more than 4 hours, or maybe even multiple trainings that combine for less than 4 hours, rather than, training every week of 4 hours each. But there's also the question of who gets to do this. It says safety committee designees. Does this mean people that are designated by the safety committee who are on the safety committee? Is it the entire safety committee? Or theoretically, can the safety committee designate other employees to be able to attend such training? Again, a lot to figure out, hopefully, with the Department of Labor taking a shot at it. There are retaliation protections in this portion of the HERO Act as well. Any employee who participates in the activities or establishment of a workplace safety committee shall not be subject to retaliation for any actions taken pursuant to their participation. I think it's just fair to assume that that's very broad protection. And compensatory and liquidated damages are available along with other remedies, similar to the other employment discrimination laws and the type of protections that employees have for taking action that's protected under the airborne disease and infectious disease prevention plan section of the labor law that we talked about at the beginning of this presentation. Just a couple more points, and then we'll get to the question and answer. I did see a question I would go ahead and answer. Yes, actually, this is being recorded. You can watch it later, and you will get a copy of the slides. If you stay on to the end here, I'll give you the link. Otherwise, you will get an email if you're registered following up sometime tomorrow to give you the link to the slides. The last couple points to make include the collective bargaining issue. So where you do have a union, the law actually does allow the union to waive their member or the employees they represent's rights under this section 27D. It's unlikely that a union is just going to summarily say, no, you're not having a workplace safety committee. It's probably more likely that they would negotiate an alternative to whatever the specific requirements are under the law itself. So maybe that they want to have more than 2/3 representation. They may want the committee to do more, or maybe less, or they just want everything to go through the existing union membership rather than have to set up some other committee. But that is possible. There has to be a specific reference now to the section of the labor law of 27D to make that waiver enforceable. Assuming there is no waiver, The law can't be read to limit any employee's rights under a collective bargaining agreement. So without a waiver, the statute doesn't displace anything that's already in place through a union contract. So if there is some other committee that is set up under a union contract and the union doesn't expressly agree otherwise, you presumably now have to have that committee plus your workplace safety committee that complies with 27D. Again, that's starting November 1st. As I've said multiple times, the Department of Labor really is not going to have any choice but to issue not just the model standards on airborne infectious disease prevention, but also guidance, hopefully, on both new provisions of the labor law. With regard to the Workplace Safety Committee provisions, the statute actually says the Department of Labor must or shall issue regulations and rules. So again, they're going to do that. As with everything else, it's just a question of how helpful those are going to be. The exact format and timing are unknown. I think it's hopeful to believe that all of this will happen before employers are expected to be complying with the law. Like I said, the model standards for the airborne plan, disease plans, have to be out before employers have to do anything. But the Workplace Safety Committee provisions, even with the amendments, are set to take effect on November 1st, whether the Department of Labor has said anything more or not. So hopefully they will do so before then with enough notice that you can actually act on it in case you have employees who are eager to get that Workplace Safety Committee up and running in November. All right, so again, in just a minute, I'm going to give the link to the slides and answer questions that have come in, and then answer any additional questions that continue to come in. So if you have questions now that you haven't already entered, go ahead and start typing those. I send out a monthly newsletter generally with updates. People who want more frequent updates ask you to follow Horton Law on LinkedIn. That way people can get those, and sometimes we put those up instantly, short updates, or we have nothing else, post all of our longer alerts and content there on LinkedIn. But you can get them there without having to wait for the monthly newsletter, or you can certainly monitor the website. Horton Law or HortonPLLC.com is our firm website. If you need to contact me again, for example, because you don't have or you have a question that you're not comfortable having addressed publicly, or if you're a client and you want to have the attorney-client privilege protect you, or just too nuanced to get into here, there's my contact information. But with that, let me go into the questions as soon as I post a link to the slides. So that should be coming up. If it isn't already, you should have the link to the slides. Go back into the questions. So yes, you'll be getting the PowerPoints you just did. I had a question of, is there any difference between New York City requirements and the CDC? So let me just briefly explain that everything I just talked about is New York state law that applies in New York City, in Buffalo, in Erie County, in Westchester County, on Long Island, and in Albany, and everywhere else within the state boundaries. The other important thing I want to reiterate is that the law I just talked about, although publicly discussed in connection with COVID-19, does not actually specifically reference COVID-19 and is not limited to COVID-19. That being said, I know yesterday the state basically changed its masking requirement, which is creating issues for everybody everywhere. Do we require the mask? If we do we require proof of vaccination? That sort of thing. And just based on that question I had, again, different municipalities might have different approaches. Different private companies have different approaches. Most of the government offices, it seems like, are still requiring masks in most public facing settings. So there, the any distinction between the CDC and New York State or a locality need to be addressed, specifically. So just because the CDC says something in New York, it's not binding on anyone until the state says it's binding on someone, which it has, for example, with respect to schools where masks still must be worn regardless of vaccination um, status. So you have to look at all the different sources, and you can't just say the CDC trumps something or the state trumps something else. You can be subject to multiple levels of guidance. There was a question that I kind of addressed earlier, but not directly. What about home care workers working in homes in the community where we don't control the environment? Again, that depends somewhat on the amendment to the legislation. The statute right now is very broad on work site and may include those places. The amendment would add the language that the employer has the ability to exercise control, which would likely exclude those environments. The amendments also include a statement that um, telecommuting or telework sites would not be included unless the employer has the ability to exercise control of such site. So I suppose you could theoretically have a scenario where you're providing the space from which the employee is telecommuting, in which case you may have control. But if it's the person's private home, you generally would not be obligated to um, control what happens in that space. The thing about the amendments too is with regard to vehicles, it would the statute as written would include vehicles if the employer has control over it. If it's any consolation, the amendment does at least also say that you don't have to post notice or post a copy of your plan in individual vehicles. I'm just going through now to find which question to answer next. Here's a good question. Do you think the Department of Labor will send out notification of the updates or guidance, or will we have to keep checking? Well, you're going to probably have to keep checking in some way, shape, or form, depending on what mailing list you're on, where you might get notice of what the Department of Labor puts out, but there's no universal system that the Department of Labor lets employers know this is what you're now required to do. And if you don't get something like that from the Department of Labor or anywhere else, it's not going to excuse you from following it. So again, if you're registered for this, you're on our mailing list unless you ask to be taken off, which you can easily do, and you will be. But we will certainly be issuing further updates. I expect to have another webinar on this once there's more tangible information, which may not be with the amendments. It may be when regulations come out, but at some point. Otherwise, like I said, you can go to our LinkedIn and we'll let you know. But for people like me who try to find out when this happens, as soon as it happens, no, there's still no way the Department of Labor lets me know. I just have to keep clicking on their websites and every other source I can to hope to get tipped off when it comes out. What happens if our employees don't want to start a safety committee? This is actually a really good question. Again, the law says you have to permit employees to have a workplace safety committee. I would read that to say that the company is not required to have a workplace safety committee, but There's a pretty good argument on the other hand, I think, that if at least one employee wants to have a workplace safety committee, then you would be required to have one. Unless the Department of Labor comes out with some guidance that provides for some mechanism of a vote or majority or anything like that, there's nothing like that now in the statute. So if you have a union that represents all of your non-supervisory employees, then perhaps, again, they can just waive it. But if you have any non-supervisory employees, then arguably the way the statute is written, they can say we're having a workplace safety committee, in which case you then have to figure out how you're going to meet the 2/3 requirements, because to have 2/3 members be non-supervisory employees, you're going to have at least two employees on the workplace safety committee plus whatever management representative you have. So yeah, that is a huge loophole or catch 22 in the legislation that I guess nobody in Albany cared about. There's a question, can a company recommend the committee use existing safety measures created? So, and you can add something if I don't understand the question right, but basically the workplace safety committee doesn't ultimately get to determine your policies and procedures. They really just have the right to review, comment, address, discuss, participate, and that type of thing. So, if you're in a union setting, it's different because so there might be things that are mandatorily negotiable separate and apart from this law anyway. But if you're just in an unrepresented workforce where you now have to recognize a workplace safety committee, it still doesn't mean that they get to generate the policies. The company ultimately is responsible for establishing the policies, just with committee involvement. And if you again go back to the two totally different things that the HERO Act is doing under the airborne infectious disease prevention plan requirement, again, if you're going to have an alternative plan, you're going to need employee involvement. Presumably, if you end up with a workplace safety committee, the workplace safety committee would be involved in coming up with such an alternative plan. I will say that as written, it appears to me that the law says whether you have a union or not, if you choose to use the model plan, you can just do that without any employee involvement. Now, depending on what that model plan includes, if you do have a union, the National Labor Relations Act may preempt whatever the state statute says, meaning that you might still have to negotiate some aspects of that as respective to unionized employees. So a lot of this gets complicated. I will say, kind of in closing, asking more questions if you have them, but there is a big problem with having this workplace safety committee, obviously where there is a union in place because of some potential interactions there, but there's also potential preemption or conflict with the National Labor Relations Act, which normally says the employer only has to recognize and basically bargain with employees if they have done what they need to do under the federal law to have a union represent them. And you could argue that the Workplace Safety Committee is effectively a union, albeit one with employer involvement. That's actually part of the reason why 2/3 employee involvement, because that's to protect against provisions of the National Labor Relations Act that would prohibit the employer from having control of a union if you were to kind of consider the Workplace Safety Committee a union. I don't want to get overly complicated on this, but all that by way of saying there are bases where there may be legal challenges to this whole workplace safety committee concept. So I suspect, in addition to whatever regulations we may see, at some point there could be legal challenges which may or may not change the enforceability and impact of that new component of the labor law. But for now, I wouldn't tell anyone to refuse to have a workplace safety committee. If nothing else, let's wait and see what we have from regulations and then what the state of things is come November 1st, subject to any further amendments that might change that date. I don't see any more questions that I haven't answered. If you have one, go ahead and enter it right now, or at least type something in so I know you're going to ask a question. If I don't see anything here shortly, I will wrap up. But thanks to all of you who stayed on this long. Do stay tuned because I do anticipate discussing this topic more in the coming months. And it will apply to many of you in one shape or form. Hopefully, the airborne infectious disease prevention plan won't be too much of a headache for anyone since we're already used to dealing with these reopening plan requirements. And again, you might not actually have to do anything under these plans for the foreseeable future other than adopt the plan and put it in place and give it to employees. And likewise, hopefully, the Workplace Safety Committee issue doesn't create major headaches for too many employers, but I'm fairly confident that it will create major problems for some. With that, I don't see any more questions. I'm going to go ahead and close up the webinar, and we just look forward to seeing you at the next one. Thanks.